We have considered the appellant supplementary skeleton and exhibited material de bene esse, that is provisionally, whether they should be formally admitted as relevant or excluded as irrelevant, either to the construction of the Commission provision, clause 13, or to the question of its reasonableness, is an issue which we shall determine as part of what will certainly be our reserved judgment on the appeal. Mr. Reid.
Thank you very much, my lords. It's the experience of those that frequently argue contractual terms that parties often reflect on what they wish they'd written rather than in what in fact they had contracted.
Yes.
And at the heart of this case, I fear that that is very much the way that my learned friend presents this particular appeal. I don't detract from the beginning of my skeleton argument at page 2, where I draw a common thread of my learned friend's skeleton argument, where he describes the obligation with which we're specifically concerned. It is in these terms. It's drawn from page 27 of the core bundle for the presence of our skeleton argument. My skeleton argument. He draws from, I draw from paragraph 49 of his skeleton, that he says of the commission provision that it only requires Mr. Javor to pay commissions to X-ray for bookings which he had scheduled or made when working as an employee for X-ray, but in respect of commission is paid after his employment was terminated. A very narrow formulation indeed of what it is said that this commission clause actually purports to do. Some distance from the contractual reality of the wording that we find. And the wording which the judge concluded, as we say permissibly as an exercise of construction, which, as my learned friend Mr. Solomon observed in his submissions before lunch, isn't the subject of a specific argued ground of appeal to this court, is one the judge was entitled to reach. Can I just, as part of that, deal with a couple of points of background?
Well, just to, before you do that,
yes.
I mean, I was speaking to myself as the judge who gave permission to appeal. You were saying, in effect, that I was misled, but what did the judge find on the issue of whether clause 13 should be interpreted as referring to bookings made, discussed, etc., by Mr. Javor or by anyone?
Well, I think we have to look at it in context as to what was argued below. But if you want to find where the judge's findings in relation to this are concerned, we find that we have to look at the argument that's advanced before him, and it's summarised on my part at page 100 in the judgment, paragraph 78. And you'll see it's 78 and 79. We articulate the wording. I can take to the relevant parts of the skeleton argument in relation to it, but you can see that at 78 and 79, we had approached the clause as making it clear that it's not limited to bookings which have been placed by Mr. Javor. And at 79, you can see that we give the example of commission being payable, even if in circumstances where there was no binding agreement to which he was subject. And that was very much the argument we advanced below in the skeleton arguments, on the question of interpretation. And if you look at the judgment,
either before or after looking at the judgment, I think we would like to see the skeleton argument.
Yes. When we look at it, you'll see that the claimant's case is shifted rather. But if you look at the judgment, what the judge finds around this is found in three places together, 99, 100 and 102. They're on page 103. And 99 sets the context because he's looking at the interpretation as part of the question of whether or not the clause has a restraintive clause effect. And if you look at that, the first sentence of 100, it's have to account to X-ray for commission received by him or a person associated with him, including a current employee of WME. And then he goes on, and even if his discussions with the client before termination were tentative, vague, and inclusive, and did not lead to the booking, and even if he was not involved in or not even aware of the subsequent booking of the same artist by the relevant person, the obligation to ensure that all bookings are contracted via X-ray is absolute and unworkable. And then at 102, he comes back to the meaning of the clause again and focuses upon the fact that the provision isn't limited in time in any particular way. Now, at the beginning of that, he says that he accepts the arguments of the defendants, that's myself and Mr. Solomon, about the width of the clause. And it would be very much our case that the clause wasn't limited to Mr. Javor.
It's not what he's found, is it? You just read it to us.
Well, I think it's, from my perspective, implicit, but I have to say it doesn't really matter in this sense, that it's quite clear, even if you read it as being limited to Mr. Javor, he's still finding that the clauses which are present there, as defined, is too wide. But it was very much an issue before him that it was wide, and you can see the problem the claimant was struggling with in relation to this. Because can I just take you back and look at the skeleton arguments?
Yeah.
So before we do that, we just need to look at something in the pleading, if I might, because it's very instructive to look at the way that it's formulated on the pleaded case. You find that at 122 in the core bundle. So the pleading has recited the clause at 28 on page 122. The way it's framed is to put it as in these terms. Claimant is accordingly entitled to and claims a declaration that the commission obligation is valid and enforceable, that all monies relating to bookings or potential bookings discussed, scheduled, made or contemplated prior to the termination of the first defendant's employment with the claimant in respect of clients and artists with whom the first defendant had material or personal contact in the 12 months before the 17th of August 2023. So in fact, the pleaded case, which we were applying to strike out or summary judgment, conflated the clause so as to try and impose a limitation on the latter part of commission as limiting it only to artists that my client had dealt with in the preceding 12 months. Now that, of course, doesn't appear on the wording at all.
It does.
Only in relation to solicitation.
Yes, but it's all in one clause. So I mean, the problem, it seems to me, is when one gets to the commission clause, it doesn't identify in any way who is the party with whom the dealings, the relevant dealings may be with. So you have to find that somewhere. And surely where you find that from primarily is in the preceding provisions of the clause. And it seems to me that this interpretation of paragraph 28 is extremely arguable. It seemed to me when I read it, that's how I read the clause.
Right. Well, you'll appreciate I read the clause distinctly differently.
But the judge hasn't read it at all. He hasn't undertaken any interpretation exercise in this regard.
Well, what he has looked at, as I say, specifically in relation to the paragraphs I've identified, is even if you take the wording even if you take it as being accepted, that in some way it's limited to the people that Mr. Javor dealt with, you still get wording which is extremely broad.
Well, I understand that. That's your case, but
yes.
I'm dealing at the moment with the, if I can say so, very fierce beginning to your skeleton argument that
Yes.
it's absolutely obvious that there's no limitation to clients with whom Mr. Javor, is that how you pronounce it, had discussions prior to the contract, and the passages you've shown us in the judge's judgment seem to assume that is what the clause means. I appreciate you say even on the narrow construction it's too wide. We'll come to that, but on the question of what the clause means, the judge refers to paragraph 100. He, the first defendant, would have to account to XR for commission received by him, the person associated with, including a current employer, even if his discussions with the client were tentative, vague, and inconclusive.
Yes, well, I'll apologise if my opening appears fierce. I appreciate your lordship was the judge that granted permission, but you'll appreciate that I read and the way that the skeleton was put as being yet another attempt to reformulate the way that the wording of the clause operates. And I don't demur from the fact that the way that it's formulated, and I've quoted at the beginning, loses, it's not just a question of editorial blue penciling, it narrows it down to a very specific exercise in bookings which have been scheduled or made in relation to Mr. Javor before he ceased to be an X-ray employee. That's the way I've quoted that particular wording. Coming back to the skeleton argument, at page 97 in the supplemental bundle, now, as I say, the pleading case was as identified. At paragraph 45.2, you'll see the way that the argument was advanced below by leading counsel, then instructed on behalf of the claimants, was not to articulate it at 45.2 as being limited to bookings in relation to Mr. Javor. I read 45.2 as ambitiously seeking the argument that it wasn't in restraint of trade, but simply embraced all of the commission that arose in relation to potential bookings discussed, scheduled, or contemplated during Mr. Javor's employment. It didn't seek to advance the limitation even in the pleaded case.
What point was made in your skeleton?
Yes, so in our skeleton, you find it in two places. You find it at page 56. At paragraph 44. As you can see at 44, it's specifically addressing the point that the wording of the clause doesn't reflect what was alleged to be the pleaded case in relation to its wording. And my learned friend Mr. Solomon, to similar effect, at page 77, at paragraph 53, little Roman 2, makes the same point from the wording.
So sorry. Page.
One thing that can be said is that the judge did not accept the submission. He did not in his judgment uphold these submissions as to what the clause means. So,
Well,
you haven't
say,
taken a respondent's notice.
well, as I read 99, I do read the judge as accepting our submissions in relation to the effect of the clause. I acknowledge that he doesn't.
Absolutely not right, forgive me. You're saying in those paragraphs, your concerns with the front end of the issue, what dealings did the first defendant have whilst an employee?
Yeah.
But what the judge is dealing with is at the back end, what happens in relation to bookings subsequently made while he's not an employee.
Well, the judge is looking at so the way it was argued below was to take the two clauses. Obviously, we're here only focusing on the commission clause. Below, obviously, they were treated as being two specific obligations. We were seeking to strike out both. We failed on the non-solicitation clause. The judge is looking quite specifically at the commission provision. I take your point that he's looking at the effect of bookings thereafter, but that flows from the meaning of the clause as one takes it.
No, it doesn't. It's a different point.
I appreciate that.
Yeah.
Well, can I park it because?
Yeah.
Well, so very simply, the submissions you just referred to us in the skeletons very properly, those did not feature, the judge did not uphold those submissions in his judgment.
Sorry? Yes, well, we think that 102 involves him doing so, but can I say, even if the judge doesn't make that specific finding, it's clear that the way we've articulated it looks at the breadth of the clause, even if it only applies to Mr. Javor. So I don't want to, if I've taken a bold position in relation to the way that it's presented, and there's no criticism of the Commission being given, obviously we looked at an argument and then we see it being reformulated as we read it. It remains the case that what the judge has clearly done at 99, 101 and 102 is actually look at the clause, even if you read him as implicitly limiting it to Mr. Javor. Because when you look at the clause, if we read it as if it's limited to Mr. Javor, it still purports to do this. It still purports to provide that all commissioner monies, and if we read that as limited to Mr. Javor, and limited in some way to those he dealt with, relating to bookings or potential bookings, discussed, scheduled, made or contemplated, and taking out contemplated, my learned friend Solomon will deal with blue penciling, but contemplated isn't really enough when you look at the paragraph afterwards, whether or not actually contracted or to be made prior to the termination of your employment, whether or not such bookings take place after the end of your employment with the company. So it's not even addressing, as my learned friend formulated it, bookings that have been made before the end of the employment. It specifically talks about things which had not been contracted, things which had been contemplated or discussed but not contracted. So it's very different to saying that this clause was directed at dealing with bookings that have been made in the way that he seeks to articulate it in dealing with our arguments.
The clause has to deal with bookings that haven't actually been contracted, does it? Because if they had been contracted, there'd be no doubt about it, entitlement to commission.
Well, there's part of the background issue which the judge deals with about at page 102 of the judgment, paragraphs 91 to 98. I entirely accept that, obviously, that one has to be careful about contracted booking. Obviously, that's the booking of the particular tour. When it comes to contractual entitlement to commission, of course, that would typically depend upon the terms that that X-Ray contracted with the artists upon. And what's clear from the background facts is, and my learned friend accepted this, is that when it comes to the contract, if a booking is made, you see it at 92, in answer to my Lord's question to my learned friend, none of the payment comes to Mr. Javor, the payment comes to X-Ray as the counterparty, and it's not made to the individual booking agent employee. And what the judge notes in relation to that is that typically you would expect that if you have a contractual relationship to act on behalf of a client, you would address the question of what you do about commission, whether or not that's an entitlement you've got, whether or not your entitlement is still there if a booking takes place after the client has moved. And what's clear is, as my learned friend said, there are no contractual written documents at all between X-Ray and the artists. And that's why, in that analysis, because it becomes relevant to what steps one might take to protect reasonable interests, the judge articulates the fact that you would have expected that that's the place where you would secure a position. So typically, take for example, if I act for you and it's proposed that I'm going to act in relation to a tour, and part of the fulfillment of that is that I book the venues, you might expect that there will be a contract between me and you that says that if you change horses, if you disinstruct me and go and use another booking agent to complete the bookings on your behalf, you still have an liability to me for some remuneration or commission, all of which is normally what you'd find in the relationship between the agent in the true sense here, X-Ray, and the artist. None of that is present in this case. And my learned friend says they're exclusive. I think that's a factual issue between us. But what he has to qualify that with is that there is no contractual right to exclusivity. There's absolutely nothing that they could point to in the background to stop a particular artist saying, I've had enough of X-Ray, I'm going to go to another agent to complete this process or carry out the work in relation to a booking of a venue that has been made. And that's, as the contractual position is, entirely free for them to do so. So what they're trying to do, and this is why it's important for the purposes of it being a restriction or restraint, is remembering that this was obviously imposed upon my client in the course of his employment. There were no previous written contract with these terms. None of the other employees had these contractual terms at X-Ray.
Sorry, Mr. Reed, for present purposes, so what?
Well, so what? There's 2 points to that. The first is obviously, if it was a standard term that reflected something which was industry standard, Mr. Solomon will deal with this in part, you'd have expected it to be a contractual term that was across the piece for X-Ray, and it simply wasn't. And it is relevant so far as the fact that he's an employee in employment having the terms imposed upon him, that when we come to look at the doctrine of restraint of trade, and we look at quantum, that is characteristically a field in which the courts are traditionally astute to make sure that someone isn't free or restrained in their ability, once leaving employment, to sell their skills. So my point is simply this, that if there's no restriction or restraint on the client's moving and going to the second defendant afterwards, if you have anything that seeks to restrain or restrict, in effect, the ability of Mr. Javor to deal with those clients, that is a restriction and restraint, as we'll see upon him, and engages the doctrine of restraint of trade. What the judge was doing here, perfectly properly, was looking at the wording of the contract and starting off with the proposition of saying, does the wording of the commission clause impose such a restraint upon Mr. Javor? Now, accepting that there's no explicit finding as we draw it to be wide, even if it's narrow, I focus upon the narrow meanings as embracing a situation that it's quite clear from the wording that if he goes to work for the second defendant as a competitor, according to the explicit wording, he has a specific obligation to ensure that that X-Ray is entitled to 100% of all applicable commissions in respect of such bookings, and such bookings being not only those which are contracted, but those which are scheduled, made, or contemplated, whether or not contracted, because that's what bookings means. So the effect of it is that he's explicitly required to act contrary to the interests of his new employer, because he's obligated to ensure that that new employer, when it deals with an artist who's completely free to choose to change who they're dealing with for booking purposes, he's contractually obligated to act against their interests, because he's required under this clause to secure that there's 100% commission back to his former employer.
But that, obviously, this doesn't in any way bind the new employer, the new agent, contractually. So the new employer isn't under any obligation contractually to pay anything over to X-Ray. The only way it could work, isn't it, is if they became in some way constructive trustees, or possibly were in some way held to be inducing a breach of contract.
Yes, and I think those are points that Mr. Solomon will definitely address in dealing with the case against his client, because obviously his client has no contractual relationship with X-Ray in relation to this. It's only my client. But I appreciate that. But take the example of the restriction here. If the money happens to pass through my hands when I'm working for the new employer, what's said to be the effect of this clause is that immediately, despite the fact that I will owe duties, probably of the fiduciary nature, to my new employer in relation to dealing with that cash, that this clause is purporting to impose upon me an obligation that I hold it in trust.
That's why I was asking whether any money passes through Mr. Javor's hands.
Yes.
And from what I understanding is that just isn't going to arise, because he's an employee. He was an employee of X-Ray, and he is now certainly, whether an employee or working under the auspices of his new agency. So no money is ever going to pass through his hands. Why would it?
Well, it's certainly the case that the accepted evidence before the court in relation to his relationship with X-Ray was that the money didn't pass through his hands, that the party that received the payment and handled it would be X-Ray. It's not directly addressed in the evidence here, but obviously he's an employee and he's not contracting personally to receive any cash or payments with clients. His new employer is, and therefore one would expect that they would be the party that would receive any payments of commission in relation to any bookings that are made.
Well, myself, for what we were told, it's more than commission, that the sums on which the commission is payable also come to the hands of the agency.
I think it can depend on the arrangements in relation to how the proceeds of the event happen. So it may, I think, it might be a specific commission in terms of an amount, or it might be a percentage of the takings in relation to that particular performance. But obviously, if it's a percentage of the takings, I do understand it's right that the producer or the venue would pass the ticket revenue through the agency, and they would deduct their commission before paying it on to the artist. I think that one has to be careful, because the arrangements can be different with different events or different
None of
artists.
this, what you say, is recorded in writing.
Sorry?
None of this is recorded in writing.
None of it with X-Ray was recorded in writing. I can't speak for his new employer, but the odd thing in relation to X-Ray, which is what the judge observed about, is that he had no real evidence as to how X-Ray had addressed, it's paragraph 95, after he's dealt with the position of how you normally deal with payment, he says whether that's actually occurred here, that's talking about how commission is dealt with by the principal, by the booking agent, X-Ray, and its clients. He says of it that whether that's actually occurred in this case is not clear from the evidence. The terms on which the booking is secured may vary depending on the relationship with the counterparty. The evidence does not suggest that X-Ray contracted on standard terms. It's a matter for a negotiation between X-Ray, perhaps acting through Mr. Javor when he was the booking agent before he left X-Ray, and the counterparty, whether his departure from X-Ray would affect the counterparty's obligations to X-Ray under the booking contract. So there were no standard terms, no written contracts, and no evidence was led about the specific terms that X-Ray had in relation to any of these particular clients. But to go back to your lordship's question, it's absolutely right that so far as the X-Ray position was concerned, the money never passed through his hands. That was the judge's factual background. And in relation to his new employer, although it's not in evidence, my anticipation is that the money wouldn't pass through his hands in those particular circumstances. We say that of course may render it a very challenging clause to apply, because he would never be subject to a constructive trust, never having held the money. But what we're looking at here is a disincentive for the purpose of restraint of trade in the way that it's articulated in the case law, either for him dealing with people or a disincentive in relation to employment. And if we're looking at employment, what you might observe in relation to it is this. As you articulated, it might be said that there is some inducement of breach, or there might be some constructive argument of trust raised against a new employer. None of those are pleaded against the second defendant in the case at this particular point in time. But if you're looking at an employer who's contemplating employing Mr. Javor, they are looking at an individual who's, on the claimant's case, subject to a contractual provision that fetters his ability to deal with clients who formerly might have been clients of X-Ray, who've moved to them in dealing with any money, or, of course, opening them to the risk of a claim for breach of knowing assistance in breach of a contractual duty or possibly constructive trust. So what we're looking at is whether or not that clause, as articulated in relation to the wording in Stenhouse, whether or not we're looking at a clause that has an impact so that it's likely to cause him to refuse business, which he'd otherwise take. That's pretty much where an individual is dealing with it themselves.
Yes.
Or alternatively, whether the existence of the provision would diminish his prospects of employment. And I say both of those are true, even if you take the narrow wording as being subject only to him. Because if he left on his own part, if a client of X-Ray left, as they were free to do, and came to him and said, do you remember that discussion which we had about a possible concert in Wembley in 2024? We want you to take that forward. He'd have to say, I can't touch that if he was not employed. I can't touch that because if I deal with that particular booking as a consequence of doing the work to make it happen and following it through, this clause says that I must give 100% of all the commission derived from it back to X-ray.
Yes.
So it's hard to imagine how that's not a clause that is something which would lead him to refuse business. When it comes to a new employer, for the very same reasons I've articulated, one can understand that a new employer looks at an employee and a market where they're completely free to deal with or accept clients from X-ray and looks at him as having a yoke round his neck that restricts his ability personally to deal with things, but also carries the risk of allegations in relation to breach. So all of that, whether you read it as being something which is limited by, in some way, from the wording at the beginning of the clause to being only artists who Mr. Javor dealt with, none of that helps us with the extravagance of the wording that we find in the latter part of the clause and the breadth that it catches. Which is why we say that that is so broad. And the judge, whether one finds him only and focusing in relation to Javor, one does find at 100, he does find the construction, page 1003, and I notice there's no appeal against this. The judge does find that on the construction of the wording, he concludes that even if his discussions with the client before termination were tentative, vague and inconclusive and did not lead to a booking, even if he was not involved in and not even aware of the subsequent booking of the same artist by the relevant person, the obligation is to ensure that all such bookings are contracted via X-ray is absolute and unworkable. And that's absolutely right when one reads the wording of that particular clause. I should say that, of course, he goes on at 102 about the nature of it being unlimited in time. And I can understand why my Lord Justice Moylan read that as being linked in to the question of it not being worth Mr. Javor's time. The phrase "not worth his while" being limited time. My learned friend tried to address that by saying, well, we know in the context that these are bookings that are only going to be in a short time ahead. And he referred to the schedule at page 150. But of course, he pulls himself by his own bootstraps there. Those were bookings. They were bookings which were in place at the point of the termination of Mr. Javor's employment. And not surprisingly, those bookings were for 2023. This clause isn't limited to bookings because the wording and the width of it is wider. And so consequently, we can see that it's so broad and unlimited in time that one goes both back and forward. It's broad enough to mean that because it isn't limited, unless you read it as subject to the 12 months before, if there was a suggestion or a discussion about a concert at Wembley 3 years ago that went nowhere at that particular point in time, if 2 years from the end of his employment, that discussion is revived and leads to an eventual booking, this clause is drafted to purport to get 100% of the commission in relation to that particular exercise.
If it's related to a director or other fiduciary, all of these provisions would simply reflect the common law of the equity. It would be a commercial opportunity, and if a director or fiduciary exploits the opportunity of the company, even if the company itself couldn't exploit it, the fiduciary is obliged to account for all profits.
Well, I think obviously, so far as the picture of a director is concerned, there's a codification in relation to those duties, which of course reflects the conduct. And I acknowledge that someone who resigns to take advantage of a maturing business opportunity has a duty to account back in relation to that particular exercise. But we have to remember what we're dealing with here. We're dealing with an employee. He was not in receipt of any form of commission or bonus. He was simply a salaried employee. And that's specifically an area where the courts, and we'll come to quantum, and the acknowledgement that that's a particular area where the courts have always been particularly astute to protect the position in relation to employees post-termination and their obligations. And it will be an interesting departure, I say an unjustified departure, if one were to take the law of restrictive covenants and restraint of trade in relation to employees and say, well, if you formulate it in a specific way that makes it equivalent to a director's duty in relation to matters, suddenly it becomes enforceable. Because
Well, maybe it's the other way around though, because this is not a standard restraint clause, and it might be said that what you're seeking to do is to impose the principles of restraint of trade on what would be an unobjectionable concept of a fiduciary or person in such position being held liable to account for exploiting existing opportunities.
Yes, although in fairness, I run the case I have to face, which is it wasn't pleaded that it was fiduciary. It wasn't pleaded that there was any breach of fiduciary duty in relation to.
No, I think that misses the point. The point isn't that that is what the case is. The point is that this clause, to a large extent, appears to be trying to achieve contractually that position.
But even if one took that position, and it's a point that Mr. Solomon makes to me, and he's right to do so, is in relation to common law, I'd be liable to discount my profit in relation to the exercise. I wouldn't be liable to account for 100% of the commission. So again, back to the effect of this, as my learned friend said, the evidence that was led below in relation to X-ray was that it could take a long time for things to...
You'd be entitled to an equitable allowance. That's certainly right.
Yes, this has no such provision. It's 100%. So, and that's not really answered by my learned friends. Well, it's difficult to work out how you'd adjust the percentage, because if you were formulating the way you described, you could frame it in terms of profit in relation that was made upon something, if that was the way that one was to formulate it, or an account in relation to expenses so incurred. But just to make the point absolutely clearly, if you had a situation where there's a mere possibility of a booking discussed or contemplated while Mr. Javor was still employed, if after he leaves, let's forget the second defendant for the moment, is approached by that particular artist to say, let's progress it, if it then takes 2 years to get to the end of that work process in order for that concert to take effect, and he receives in his hands the proceeds having directly booked it, this clause says you must give 100% of the commission you've made in relation to it with no account whatsoever of any labour that you have. And going back to my earlier proposition, if you're looking at whether or not it's in restraint of trade and looking at whether or not it's something which would lead him to turn away business, it's hard to imagine something which would lead you more to turn away business if you were not able in any way to bring into account the cost, time and effort that you engaged in bringing something to fruition.
Sounds like you can raise a lot of tribal issues.
I don't think I need tribal issues. I think this is, I have to say, I think the judge was, and
Don't tell us what you think, Mr. Reed. You might think all sorts of things, but your submission.
Yeah, my submission is absolutely clearly that the judge was entitled to read the clause in the way that he did. Whether I'm too bold in my interpretation of it if you read it more narrowly in the way that I've been invited to do, it remains the case that he made the conclusions at 99 through to 102. And those are conclusions of interpretation which are open upon the wording of the clause, and we would say are absolutely conclusions he was entitled to reach, remembering this of course was an appeal upon that particular wording. And what he was doing is something which has been clear from one of the cases which was raised below before him, are Buthanot and rulings about the first thing a court does with a clause that's said to be in relation to restraint of trade is to construe what the clause means. And that's what he's doing, and then applying accepted principles. So I've dealt with that in response, just dealing with the more structured part of my argument in relation to things. Can I just deal with ground one? And ground one is the summary judgment appeal. And taking my Lord Justice Phillips' observation in relation to tribal issues, what the judge had fairly and squarely before him was no real issue between the parties as to the principles of summary judgment. And I acknowledge that at paragraphs 3 and 4 of the judgment, it's page 89, he summarises those succinctly, referencing Easy Air Limited and Opal Telecom. And that's not surprising, because that was what was advanced before him by the parties as to the principles to be applied, and also by the claimant. And you find that in their skeleton argument.
Well, I don't think there's any controversy about that.
I'm sorry?
I don't think there's any controversy about paragraphs 3 and 4 as a
Well, the
statement
controversy
of
is,
principles to be applied on a summary judgment application. The question is whether you put them into effect. But that's doesn't seem to me, unless I've missed something, that there's anything very startling about 3 and 4.
yes, I think the controversy, with my learned friend's ground one, is to say, obviously there's an argument about whether or not the principles have been applied. That's a slightly different issue.
Yeah.
His controversy on ground one is to say that the judge failed to consider a variety of other principles drawn from a number of other cases, none of which were placed before the judge below. And the judge below was approaching summary judgment on the basis that there was no substantive issue between the parties as to the principles to be applied. So my learned friend is inviting to say there's an error of law in not having considered some wider base. Now I acknowledge, of course, he's entitled to point to something in the way that it was articulated in relation to Easy Air, that there's an issue, but it's, we say, not a proper ground to challenge that the judge failed to take into account propositions which weren't placed before them. My learned friend's predecessor, just for your note, in his submissions, we have a copy of the transcript, in his submissions at page 109 in relation to the summary judgment position. It's in the supplemental bundle. He said, this is Mr. Croxford, the next stage is on the approach to strike out on full summary judgment. I think we've broadly agreed on that. There are a couple of points worth noting at this stage. Now, you are, and my learned friends were suggesting that we were wrong about this.
Sorry,
Of course, entitled to
109.
sorry, it's 109 in the supplemental bundle.
Yes. Yes.
So we were not actively in dispute, so it's not really an error to say that the judge failed to consider specific principles. I acknowledge that an argument that's advanced here and is articulated below is about whether or not there was a need to investigate the facts. But of course, in terms of investigating the facts, the first point that my own friend seems to rely upon is to say that because the solicitation clause is going to trial, in some way that's a reason not to grapple with the application in relation to the commission clause. And we say, well, there's no reason to think that there's anything in relation to the evidence in respect of the solicitation clause that will have any impact in respect of the interpretation of the construction clause, because we're looking at it as a freestanding clause. And really, ultimately, if my client is entitled to say that that part of the clause is unlawful restraint of trade, as a matter of construction, he should be entitled to seek it struck out, regardless of whether or not there's a trial in relation to another part of the contractual position. In terms of factual investigation, it remains the case that it's not clear what is said to be the evidence that is going to be adduced at trial, that is going in some way to assist or elucidate the interpretation of this particular clause. We've accepted, and we take it at face value, the factual background as set out on the claimant's evidence before the court. There's nothing pointed to by my learned friend to say, well, there's a specific area of fact that needs disclosure or to be examined at trial that's going to help with the wording of construction in the way that I've articulated it and its breadth.
What about reasonableness?
Well, reasonableness ultimately has to be judged in the effect of wording. And one characteristic feature of reasonableness is going to be whether or not other wording or a narrower formulation of the wording might be more effective. So, for example, to take my Lord Justice Phillips' observation, that if you were to say that it was possible to formulate it in a narrow way that defined it quite tightly to specific bookings with an obligation only to account for profit made in relation to them rather than the totality of commission. All of that doesn't need an investigation as to reasonableness in terms of the evidence. One can see that if the clause is too broadly drafted, as it stands, classically it will fall as being in restraint of trade. They are the drafters of the clause, and clearly it's necessary for them to draft it in a way that is no more onerous than is absolutely necessary. So Solomon will deal with reasonableness, but we say that reasonableness is mixed in with the question of construction, because you have to start off with what the clause means, and if the clause is so broad, reasonableness never really runs as an argument, because your clause wording simply exceeds anything that might be in reasonable protection of any interests that you've got, which is what we say is the case here.
I think in terms of what are the facts that one might wish to investigate, it seems to me that there's a great deal of uncertainty, despite the help from both parties, as exactly how this industry works, and in particular how respective parties' businesses operate, and what your client and other agents' role is in that context, and specifically the relationship between them as individual booking agents and the corporate entities. None of which seems to me to be very clear at the moment.
Well, can I respectfully disagree with that? In answering your question, obviously I've indicated a degree of uncertainty about the way that aspects might operate, because it's not in the evidence, with my client and the new employer. What was clear and is identified in the judge's judgment in the background facts is that Mr. Javor did not receive the cash. So the element that's unclear, and the judge says no evidence about, is not about his contractual relationship in relation to the artists. It was a lack of clarity about X-Ray's contractual relationship with the artist. The key factual point that's clear is that he never received the cash. And that isn't something which is uncertain or resolved by factual further inquiry. It's also not in dispute, because it was the claimant's case, that it can be a long gestation period from the inception of the idea about a booking to that booking being made and taking place. So the areas of uncertainty are all about, actually, as the judge observed, why X-Ray hasn't got a set of obligations, or appears to articulate that it had a set of contractual obligations with its clients that directly dealt with obligations in relation to commission. So I respectfully suggest that, actually, when it comes to the facts that matter for the purpose of this particular clause or obligation, the inquiry doesn't take us anywhere. Can I deal with ground 2? And ground 2, I think I've significantly dealt with in relation to the earlier parts of my argument, which is whether or not the clause is in restraint of trade. In Stenhouse Phillips, can I say, it's not clear to me whether Stenhouse and Phillips was after a trial. Paragraph 12C of the judgment, it's on, sorry, page 12 of the judgment, in Stenhouse, it's page 12 on in the court's authority module.
As I recall, it's not clear whether witnesses gave oral evidence in the Supreme
Yes.
Court of New South Wales. What is clear is it's not an interlocutory decision.
It certainly seems to follow hard upon the issue of the pleadings. I think
Yes.
we tried to find below,
Yes.
because if you look at 12C, I think the claim was issued on the 3rd of July 1972,
Yes.
and it seems to have come to being struck out on the 26th of October of that year. It would be surprising if it was something to try. We tried to find out, I recollect, below, as to exactly what had happened by trying to look back at the law reports, and we couldn't get a clearly definitive answer. I only observe that. It doesn't really help, though, to say this should go to trial, whether or not that case was decided after a trial or decided on an interlocutory basis. What matters is obviously the principles that are applicable in relation to it. And those very clearly one finds paragraphs on pages 14 and 15. And although the contract had 2 clauses that were found to be in restraint, clause 5 and clause 6, it's worth noting that they were of different duration. So clause 5, the clause that provided for payment of money derived from insurance placed with clients, continued for a 5-year period, and the non-dealing with clients was for a 3-year period. My learned friend suggested I led the judge to misunderstand that. Actually, if you look at the judgment, I made it very clear that what wasn't the case in Stenhouse was that there was a non-compete. There was no clause saying you can't compete. Okay. There was a clause saying you can't deal with the clients for 3 years, except if you comply with the obligation under 5 and pay us a commission. And 5 went further, and so year 4 and year 5, he was free to deal with the clients, but he had to pay the insurance, the 50% of what he derived from dealing with those clients' insurance business back to his former employer. And the phrase which I refer to about the effect of the clause being to cause the employee to refuse business or otherwise would take, or looking another way, whether the existence of provision would diminish the prospects of employment. You find that at the bottom of page 14 and the top of page 15.
Yes.
And that's very clearly being articulated about clause 5. And it's an observation I've made already. That case had a 50%, this is 100%. And so we say the principles of Stenhouse for restraint of trade very clearly capture what's applicable here. That the facts may be different, the analysis of those particular facts may be distinguishable, but the core principle of whether or not the effect is restraint is, as articulated, quite clear in this particular case. I'm passing, before I deal with ground 3, a point's made against me that it hasn't restricted the capacity of Mr. Javor to seek employment with the second defendant, and that must be a point to suggest that there is no restriction in relation to restraint of trade. Of course, what's clear on the evidence that Moylan has identified is that the second defendant formed the view, we say properly, that this was an unenforceable clause, and therefore there was no disincentive in it because it was unenforceable. But of course, the fact that he was able to find employment is not a fact that's relevant to the construction of the clause at the date of its contraction. And as my learned friend accepts, when it comes to interpretation of the clause, you're looking at it at the point the parties contract, at the point that Mr. Javor entered into the obligation. And at that point in time, as I articulated, it's quite clearly something which would either make him turn away business as an agent on his own account, or impact upon his ability to seek employment because of the fetter that he would come with. Can I then turn to ground 3? And this touches on something which I referred to in passing before, which is the question of the suggestion that this is an industry standard. Ground 3 focus on the argument that this clause isn't subject to the doctrine of restraint of trade, and for those purposes refers to, as she then was, Lady Justice Carr's judgment in Quantum. And, my lords, you find Quantum in the bundle of authorities at page 437. And the first, we don't need to go into we don't need to go into the underlying facts, just to start with this observation. Quantum was not looking at restraint of trade in relation to the employment field or obligations imposed upon an employee post-termination. It was a clause that was negotiated in a service agreement between an LLP and another company. It was a commercial contract struck between two commercial bodies. Now, it's right that what the court does in Quantum, and one finds it at page 456 in the bundle, that in the authority itself it's page 492. having outlined the law in relation to the doctrine of restraint of trade, Lady Justice Carr draws together the relevant legal principles, but she's doing so on a broad canvas because she's looking beyond an employment relationship. And it's worth noting that the first little Roman one makes the observation the doctrine is not confined to immutable boundaries or rigid categorization, but there are certain categories of covenant to which the doctrine traditionally applies, in particular those by which an employee undertakes not to compete with his employer after leaving the employer's service, and those by which a trader who sold his business agrees thereafter to compete with that purchaser of the business. The doctrine is held to apply to franchise agreements, share purchase agreements, and the assignment of a patent. So, although she specifically talks about non-compete there in relation to employment relations, the principle is the same, but that's one of the accepted categories where the doctrine of restraint of trade has applied. And she goes on then to look at the nature of the test, and the passage that my learned friends relied upon in their skeleton is at little 3, where she said contractual restraining provisions which are of a sort which have become part of the accepted machinery of a type of transaction which have generally been found acceptable and necessary, reflecting the accepted and normal currency of commercial or contractual conveyancing, all contractual conveyancing relations will generally fall outside the scope of the doctrine following the trading society test discussed above and approved in Peninsular Securities. Now, my lords, we are there looking at the outer reaches of the doctrine of restraint of trade. And what she's referring back to there is that in the case of Peninsula, the Supreme Court reversed the previously accepted approach to restrictive covenants in relation to land in leases by taking a different approach. Traditionally, following Esso Petroleum and Marden, the approach had been that if a party had previously had a freedom to deal with land as they wished, if the contract sought to impose a restriction upon that, that caught the doctrine of restraint of trade. And in Esso, Lord Wilberforce gave a dissenting judgment that adopted a different approach. And the different approach was to say, well, if there is, in order to effect a trading, as part of the trading society, a recognised form of structure whereby parties contract with restrictions, then that's not within the scope of the doctrine. So when one looked at a lease, if it was common as part of leasehold provisions to see restrictions being placed on the use of land, whether or not of a particular nature, whether or not that was something that was free originally to the person who held the land or subject themselves to that particular restriction, that wasn't immediately in the doctrine of restraint of trade. Now, my point about this is that that clause, that little passage, is dealing with a very, very specific area of contractual relations, and isn't clearly, when one's looked at the background of her reasoning, dealing with the clearly accepted propositions that the doctrine of restraint of trade applies to restrictions which are sought to be imposed upon an employee after the end of the employment relationship. Now, my learned friend's argument is to say, well, in some way, there is a set of industry provisions here that are so woven into the framework of the way that agents and their employees act, that these have become part of the transactional norm. It would have to be, to even apply the reasoning in that part of the judgment in quantum, it would have to be something that was part of the normal trading arrangements. And the problem with that is that the evidence he led, even if we accept that as being at its highest, what's established, falls far short of that. My learned friend took you to the passages, but it's worth just turning them up again. You find them, my lords, in the witness statement of Mr. Huffam, and that's at tab 5. And the high watermark of their evidence in relation to this is in 2 places. Paragraphs 33 at the bottom of the page. He's talking of clause 13 and commission, and he's talking about not the specific clause at this particular point in time, but the idea that the agent who was responsible for the initiation of a booking would be entitled to the commission. And what he says in relation to that, if you look at the end of that passage, he says, we can see it 6 lines up, there are multiple initial considerations before the idea for a tour or concert gets a green light, which in turn puts the rest of the process into motion, which in due course leads to the artist stepping foot on stage. These first questions are critical. So if a tour or show was being contemplated...
Sorry, but Mr. Reed, which paragraph?
I'm sorry, it's page 33, paragraph 22, bottom of the page.
Yes, sorry. Carry on.
Sorry, so he said these first questions are critical. So if a tour or show was being contemplated before Josh left, X-Ray wanted and expected to be able to commission if it came to fruition. I believe this generally would be viewed as industry standard, generally viewed. So he's not saying there is a specific clause that is always accepted to be put in the contracts of employment in relation to former agents. He's merely articulating the view, his view, that there was a general view as an industry standard that the initiator of the process to a booking would be entitled to the commission. So that's not the same as saying this is part of the trading society in terms of a standard term in the contracts of employment of agents in people such as X-Ray. To the same effect, if you turn the page, this is the second place where we get anywhere close to such a case. It's page 35, paragraph 22. He says, I've been asked, sorry, paragraph 28. I've been asked by our lawyers whether in my experience the provisions of clause 13 are fair, reasonable and necessary. I've been in the music industry for 30 years, but I've also discussed the question with Scott Thomas, who has 35 years of music industry experience. Scott agrees with me that this type of clause, though perhaps not uniform, well, how can it be part of the accepted trading society for employees in relation to that particular industry if it's not a uniform clause that's applicable in relation to contracts of employment? And it gets worse than that because, of course, this clause wasn't even in the contract of Mr. Javor until long after the commencement of his employment. They included it in the written contract that's the subject of the hearing before this clause. And the evidence was from Mr. Huffam is that they didn't normally have written contracts at all for their employees in relation to contracts. So all of that is wholly inconsistent, even on their own case, with this being a clause that is elevatable to the point of being something which is so part of the framework that it falls outside the doctrine. It's quite clear that this is fairly and squarely, we say, applying Stenhouse within that area that the courts have long recognised as being one that they are astute and careful to police about restrictions that continue on beyond the end of an employment relationship. That's what I wanted to say about 1, 2 and 3. I can't propose there may not be some degree of overlap particularly as my learned friend Solomon no doubt has heard me say things and thought of them in a better way. But he's going to take the floor, if I may, yield to him for 4, 5 and 6.
Yes. Yes, Mr. Simon.
I'm grateful, my lord. I'm going to address 4, 5 and 6, if I may, but first may I say a few words about the claim specifically against my client in respect of the commission obligation and its contention that the claimant appellant's contention that it should be permitted to bring a claim against my client for declaratory relief only. You were not addressed at all on this point by my learned friend Mr. Goulding in his submissions. The starting point must be the way in which the claim was put below. And if I can ask your lordships to turn to particulars of claim, which are behind tab 9 in the core bundle, starting at page 110. And if your lordships go to page 122, perhaps turn back to 121, you'll see the title Commission Claim. That's where it starts, the bottom of 121, paragraph 26. Then over at page 122, and it's formulated in this way. At paragraph 28, there's a claim for a declaration that is sought, and at paragraph 29, it says further alternatively, defendants threaten to act in breach, and at 29.2, the first defendants thereby in anticipatory breach and or breach of the commission obligation, and the second defendant is liable for inducing breach of the same. So we understood, when we were going to the summary judgment strikeout application, that we were facing a claim for inducing a breach of the commission obligation, albeit said to be an anticipatory breach. Submissions I made below, you can't induce anticipatory breach. At the hearing, the claimant's counsel, Mr. Goulding, confirmed that there was no claim for inducing a breach of the commission obligation. He abandoned that point, and you can see that in the supplemental bundle at page 123. At the top, paragraph A, Mr. Justice Kerr said, are you or are you not accusing the second defendant of inducing a breach of the commission obligation? Mr. Croxley said, not at the moment, no. And then at F, again, so am I right? You do not accuse the second defendant of inducing breach of the commission obligation, correct?
Sorry, which page?
1, 2, 3, my lord, of the supplemental bundle A and F. And then over the page at 124, A to B, went on, so there's no plea of inducing as against D2 breach of the commission obligation. That means that D2 is off the hook apart from declaratory relief. And Mr. Cox said an inducement in relation to, and he's going to say the solicitation claim, and as Justice Kerr said, I'm talking about the commission obligation, yes. At this stage, on the basis of the evidence we currently have, we're seeking a declaration on the commission obligation because it will assist us. That's what he put it. And this was confirmed in the judgment. So your lordships go back to the judgment behind tab 8 of the core bundle. At page 101, paragraph 90, Mr. Croxford accepted an oral argument. Particulars of the claim would need to be supplemented in order to plead properly the claim in respect to the commission, so far as XR seeks to rely on WME holding on trust for XR monies received directly by WME for performances discussed or arranged by Mr. Javor, falling within the scope of the commission provision. That should not impel the court to strike out the claims against WME in respect to the commission provision, the relief source at present limited to declaration. This is Mr. Croxford's submissions. And then at page 103, paragraph 104, the judge again picks this up. It says there is no present claim before the court against WME for damages or any other monetary remedy for inducing breach of the commission obligation. There is an imperfectly pleaded claim against WME asserting it's induced Mr. Javor to commit an anticipatory breach of the commission provision, that it holds or may hold monies on trust for XR as a consequence. The only relief sought is a declaration the commission provision is valid, proposition I've rejected. In my judgment, any claim against WME arising from the commission provision is doomed to fail. Even if the provision were valid, WME is not bound by it. WME's liability to XR would have to rest on some principle of trust law, restitution, knowing assistance, or some other cause of action. Lest the provision itself were enforceable, it's impossible to see how such cause of action can be established. None that has any chance of success at trial is pleaded. So the claim against my client was struck out on different grounds against which there is no ground of appeal advanced now. It was struck out because there's no pleaded claim in respect of the commission obligation that could have any grounds of success. And there's plainly no basis, given that, for any declaratory relief. We say that there is obviously no need for a claim against my client for declaratory relief to proceed. There is no appeal against paragraph 105. We had asked repeatedly...
It depends what it means. In the last two sentences which you've quoted, unless the provision itself were enforceable, it's impossible to see how any such cause of action could be established. So that's if Mr. Goulding fails against first defendant, he must fail against you.
Yeah.
But you say that the meaning of the last sentence is anyway there is no pleaded claim for breach of trust, restitution, and so on.
Yes.
Separately.
Yes.
It's a very concise passage in the judgment. Apart from that sentence, it's stand or fall together, don't they?
What the judge is saying, and based on the submissions by Mr. Croxford below, is that there is no properly pleaded claim for any known cause of action against my client. And in order for a declaratory relief claim to have any form of success, it's got to be based on some form of claim. Otherwise, it's completely worthless. And there is no pleaded claim. And it's obvious from the particulars of claim that that's right. There is the way it's put in the particulars of claim, your lordships can see at page 122. In the core bundle, is that paragraph 27 asserts that the clause is not in restraint of trade, and then paragraph 28, this is the declaratory relief claim, the claimant is accordingly entitled to and claims a declaration that the commission obligation is valid and enforceable, that all monies related to bookings, potential bookings discussed, scheduled, made or contemplated prior to the termination of the first defendant's employment with the claimant in respect to the clients and artists with whom the first defendant had material or personal contact in the 12 months before 17th of August 2023 belong to the claimant, and insofar as they have been or received by the defendants, they are held on trust by the claimant. That's the totality of the pleading against my client. There is no basis whatsoever as to how a trust could have arisen because of some contractual relationship between the claimant and Mr. Javor. Not set out at all, not expounded, and Mr. Croxford in oral submissions accepted that he'd need to do some work to flesh out what was meant by that. But just pausing there for a moment, the declaratory relief sought, as Mr. Reed said, is not in the terms of the commission clause. So there are two significant limitations on the terms of the declaratory relief sought. One is that the first defendant had material or personal contact. And Mr. Reed has addressed the court on that. But the second is that there's a 12-month retrospective period that limits the contact, and that isn't found anywhere in the commission clause. Now, my Lord Justice Phillips said in discussion with Mr. Reed, doesn't that arise from the non-solicitation clause? Isn't that read in? But that is specifically disavowed by Mr. Goulding in his submissions. He was making submissions on reasonableness, and he said to your lordship that the absence of a time limit is not of material significance. The time limit is an inherent limit. There's an inherent limit placed on the clause because of the obligation that Mr. Javor himself should have made the booking. That's what the submission Mr. Goulding made to your lordships was. So the terms of the declaration are disavowed by Mr. Goulding's own submissions to this court. But as to the two limitations, we make these short points, that not only can't you read across the limitations in the non-solicit clause into the commission obligation, but precisely because the non-solicit clause has those limitations in, is a reason why they should not be read into the commission obligation. If that's what the parties had wanted to do and intended, they would have used the same wording, but they specifically didn't. And they specifically didn't have any retrospective period as well. So the terms of the declaratory relief against my client are unarguable, and there is no basis whatsoever, we say, to seek declaratory relief against my client. Your lordships haven't been addressed as to how it would be of any assistance whatsoever to the claimant to have a declaration when there's no pleaded cause of action for damages against my client.
Well, in Rolls-Royce and Unite, Lord Justice Aikins said, power of the court to grant declaratory relief is discretionary.
Yeah.
Each party must generally be affected by the court's perspective. There must generally be a real and present dispute between the parties before the cause as to the existence or extent of the legal right between them. However, the claimant does not need to have a present cause of action against the defendant. The party must in general be affected by the court's determination of the issues concerning the legal right in question. Not the party to the relevant contract in respect to which a declaration is sought is not fatal to an application declaration, provided it is directly affected by the issue.
Yes, but we're not. So we cited, I advanced the Rolls-Royce argument below. We've cited that in our skeleton argument to this court. I accept as a matter of principle, you don't need a cause of action to have a declaration, but there must be some basis for you having declaratory relief. It can't be enough to say we want it to get declaratory relief. And if Mr. Goulding's right that his clients have got a money claim against Mr. Javor, they don't need it at all. Because if there's no money claim against my client, a declaration that the clause is in the terms that it is has no value whatsoever.
Well, it might be quite useful for them in the industry, for a declaration that Mr. Javor, that the commission that is earned on these contracts is one that Mr. Javor ought to have arranged to be paid to the claimant.
If they're right that it's enforceable, they'll have that in the judgment because they'll win against Mr. Javor. So it gives them nothing more than they would have in the claim against Mr. Javor. The reason my submission at this point hasn't been addressed at all, I addressed it in my skeleton argument, but it's not addressed at all by the claimants. It's because there's no basis whatsoever for any declaratory relief against my client. It just falls away. It's meaningless. It is trying to sound a bell in a vacuum, my lords, in a phrase Mr. Reed said to me when discussing this point. So there's no industry reason at all, because there would be a judgment if the claimant is right against Mr. Javor with declaratory relief against him and financial recovery against him. That's all it needs. So in it, those are preliminary points. I will deal quickly. I understand it's 3:25.
Yeah, it was the adjective preliminary, but preliminary points are sometimes main points. Right,
Well, it might be.
keep
main,
going.
I mean, I'm happy, my lords, if
Yes.
that's the main point, and,
Yeah,
and,
no.
you're happy for me to stop there. But
Yeah,
I'll
no.
make some brief points again
Not
about
saying
rounds
that.
4, 5, and 6,
Yes.
if I may.
Yes.
All these grounds are argued now before your lordship as if argued for the first time, and this is in fact an appeal. And so what has to be advanced is that based on what was said and put before the judge below, the judge made an error of law. And so this ground is that the judge failed to consider or identify X-Ray's legitimate business interests protected by the commission obligation. Our criticism below of the way in which the case was put is that the claimant had entirely failed to identify any legitimate business interest. And that's the way in which the argument arose. So we say, and we said below, it wasn't addressed at all in the particulars of claim, and it wasn't addressed at all in the skeleton argument, and only addressed very briefly orally by counsel for the claimant. So I'll make good those points very quickly. I can show you where those where it's identified in the particulars of claim, my lords, which start at tab 9. At paragraph 26, on page 121, the commission claim is dealt with, and then at paragraph 27(1), over the page at 122, it says restraint of trade doctrine doesn't apply, and then 27(2) says the language of the commission obligation in any event is of the kind commonly incorporated in employment contracts in the music industry and has a legitimate commercial purpose where it seeks to ensure that the claimant fairly and properly retains the products of the first defendant's work during his employment for the claimant. Now, we had said in pre-action correspondence that the clause was unreasonable, and we had said, or the part of the defendants had said in terms, that it protected no legitimate commercial interest. So this pleading, the way in which it's put here, is in the teeth of what the claimant knew would be the defendant's position. The skeleton argument, and for your note, that with the correspondence on the 11th of August 2023 is at page 221 of the supplemental bundle at paragraph 8c, little Roman 1. And this particulars of claims sent about a month later in September. The skeleton below is in the supplemental bundle at page 97. And your lordship can see at paragraph 45.4, this is how it's put, commission obligation has a clear and obvious commercial purpose, namely to ensure X-Ray fairly and properly retains the product of Mr. Jedgel's work.
Sorry, I'm not
Page
for the first time I'm
97,
behind you.
paragraph 45.
97 in the supplementary.
Yes. 45.4.
Yes.
The commercial purpose is to ensure X-Ray fairly and properly retains the product of Mr. Jabil's work during his employment with X-Ray. So it's dealt with in one line, although it doesn't expressly state in terms that that was the protectable, legitimate business interest. And we say, presumably, it's because there was no protectable, legitimate business interest. In oral submissions, it just says it's commercial purpose, my lord, rather than legitimate business interest. And I'm using the term legitimate business interest because that's the term used in the cases, like TFS that my learned friend has referred to, which I referred to very briefly. In oral submissions, the way in which it was put was this, at page 114 of the supplemental bundle, at D to E, Mr. Croxton said, if it's a restraint of trade, the commission obligation, we say, it is enforceable because on any view, in support of what we suggest and plead, is an entirely legitimate aim, as your lordship pointed out. It is getting the commission for work done by X-ray. The oral submission is that it's commission for work done by X-ray. That is the full extent of the claimant's submissions on legitimate business interests. I've shown you the particulars of claim skeleton argument and the oral submissions. Of course, getting commission for work done by X-ray does not describe the way in which Mr. Goulding has put the clause to your lordships today, which is limited to work done by Mr. Javor. He says that that limit necessarily implied into the commission obligation. And there was no case referred to by the claimant appellant below which suggests that getting commission for work done by the employer could be a legitimate business interest. Now, what a legitimate business interest in the context of the commission clause might be protecting a trade relationship with one of the bands. But one presumes they did not cite that as a legitimate business interest because that would make it obvious that the commission obligation is in fact a restraint of trade. And that's why they shied away from that. So all parties below, my lords, referred to the case of TFS as the correct legal approach to assessing covenants. And if I may refer to that very briefly, it's in the authorities bundle at tab 9, page 161. I just refer to it 161. And it's paragraph 37, where Mr. Justice Cox sets out the three-stage process. First, the court must decide what the covenant means when properly construed. Secondly, the court will consider whether the former employers have shown on the evidence they have legitimate business interest requiring protection. In this case, as will be seen later on, the defendant concedes TFS has demonstrated on the evidence the legitimate business interest to protect in respect of customer connection, confidential information, and the integrity and stability of the workforce. Pausing there for a moment, that is the classic triumvirate of legitimate business interests. My learned friend says that the categories aren't closed, and it may be, for example, that you can justify a protection of a supplier clause, like, for example, the second sentence of clause 13 in the contract that your lordships are considering today. But in almost every case attempting to determine a legitimate business interest, an employer has to pin its colours to the mast of customer connection, confidential information, or protection of the workforce. And what the claimant has done here is shy away from that because it's so committed to this clause not being in restraint of trade, and assert that it's somehow the commission for work done by the claimant that is the legitimate business interest.
Well, that's because most clauses which are said to be in restraint of trade relates to customer connection, confidential information, or integrity or stability of the workforce. And this is it's unusual where the attack is on a clause, the aim of which is to protect the assets of the company.
Well, there are lots of clauses that are deemed to be restraints of trade where in fact they are not expressly restraining trade. So for example in Stenhouse or Marshall, what happens is that there is a disincentive on the employee, ex-employee, because they either have to give money back or don't get paid bonuses. And the purpose there is still to maintain the client relationship of the ex-employer. That's the reason that the clauses are in place, to try and protect the proprietary interest with the employer. It's not simply to get money. And as far as I'm aware, there is no case ever that has held a legitimate business interest is getting commission for work done. And that isn't the sort of business interest that is protectable by restraint of trade clauses. And it's against that background where the burden is on the claimant, as per TFS, to demonstrate that there is a legitimate business interest and to show that it is legitimate, that this ground of appeal must be assessed. So the claimant's position is that the judge completely ignored the question of legitimate business interest. I've shown you how the claimant put it.
What did the judge say about legitimate business?
Yes, the judge said precisely, my lord, what the claimant had said in its particulars of claim. So I've shown your lordship paragraph 27.2 of the particulars of claim at page 132 of the budget. And if your lordship goes to the judgment at paragraph 85, page 101 behind tab 8, it repeats word for word what is said in the particulars of claim.
Yes.
So what the claimant says is that the judge completely overlooked that, completely overlooked the question of legitimate business interest. And
Yes.
we say either that's wrong as a matter of fact because the judge set it out here, so the judge repeated the claimant's own formulation, or that the judge was unable to identify legitimate business interest because one wasn't properly articulated by the claimant below. What the judge has done is simply repeat what the claimant has said.
Yeah, but that's what Mr. Croxford said. What was the judge's conclusion on it?
Well, the judge, I accept, does not say in terms this is under the reasoning and conclusion section that this is a legitimate business interest. But what he's doing is following the guidance in Stenhouse. And if I can ask you to turn that up again, it's a case your lordships have been referred to already behind tab 1.
Yes.
At page 400, page 12 of the bundle, between C and D, Privy Council said their lordships consider first the provisions of clause 4. There is no doubt they are in restraint of trade, so the only question is whether the appellant can show that they impose no greater restraint than reasonably necessary protection. And that's what the judge was considering from paragraphs 91 onwards. He was considering reasonableness. And so perhaps he assumed in the claimant's favour that there was a legitimate business interest. We had argued below that there was none. And we accept, in order to justify a clause as reasonable, there has to be a legitimate business interest. And we say the claimant's failed to show one on its own terms.
Well, why didn't the Privy Council then in Stenhouse say the commission clause is hopeless because there is no legitimate business interest to support, and so we need not go into was 5 years too long and all that sort of thing. What they say, they go pretty well straight. They say it's in restraint of trade, and it's all they set out 3 provisions, and in aggregate, it's a substantial element of restraint of trade, and they say it's unreasonable.
Yes.
But
Yeah,
why is this authority? It's obviously high authority. Why does that support the argument that this is simply not a protectable interest at all?
it supports the argument, my lord, that the judge made no error in approaching it in the way he did. That once he's decided it's a restraint of trade, the only question is whether it goes too far to, it goes no further than is reasonably necessary for its protection. And that's the approach the judge took. What the claimants say is the judge made an error by failing also to set out in terms that there was a legitimate business interest. My response to that is, first, it's not an error. That's exactly the approach the court took in Stenhouse. Secondly, and in any event, it's based on the way in which the claimant advanced its case below, and it had conspicuously failed to advance a proper legitimate business interest. And if there's criticism of the judge, it's that he assumed or proceeded on the assumption that they had demonstrated a legitimate business interest in their favour. And that isn't a legitimate ground of appeal to this court, that the judge didn't strike out the case on another basis, namely that there was no legitimate business interest. And the way it's now put in the skeleton argument is simply not the way it's been formulated below. It's a matter of record, as your lordships have seen. Ground 5 is that the judge erred in his approach to severance. As to this, my lords, there is no obligation for the judge to consider severance of his own motion. The court has an ability to blue pencil certain matters pursuant to the test set out in Egon Zender in order to clean up the claimant's legal litter, which is the phrase the court used, Supreme Court used in that case, if it's persuaded that it should. So again, one must assess ground 4 in the context of the judge's refusal to blue pencil various words, various candidate words, where it's put in the skeleton argument now, against the way it was argued below. So in Egon Zender, my lords, you've been shown it, and my Lord Justice Bean is intimately familiar with it, having referred to it in other cases. There are 3 points. I'm not going to go to the case unless you want me to. 3 points set out, paragraph 87. First is that severance can only occur when the removal of the provision would not generate any major change in the overall effect of all the post-employment restraints. Secondly, the burden is on the employer to establish that proposition. And thirdly, the focus is on the legal effect of the constraints, which will remain constant, not changing significance for the parties. So, taking a step back, the way in which it was argued below is this. Severance was not addressed at all by the claimant in the particulars of claim. And that is surprising, one might think, because what the claimant is doing in the context of the pre-action correspondence, where the defendants had said in terms, this is too wide, so reasonably wide, the claimant simply says, it isn't unreasonably wide, it's enforceable. Not only is it enforceable, but we want a declaration that the terms of this clause are enforceable. So they're making a positive assertion that there's no need for any severance. Secondly, severance was not addressed at all in the claimant's skeleton argument below. As to the oral submissions, I've put in the references in my skeleton argument at paragraph 70, page 65 of the bundle, to where the claimants have addressed severance below. I take you through some of the submissions very quickly, so you lordships can see how it was put, and see how the argument.
Can we just turn up the paragraph in your skeleton, which is going to provide a guide?
Yes.
Which paragraph?
70, page 65.
Thank you.
So just going through, I can go through this very quickly for your lordships, but it's for the proposition that I'm just going to make good on the proposition that the claimant didn't set out its case that properly, that there should be severance. It didn't address the test in Egon Zender, and it didn't at all mention the candidate words which my learned friends advance on appeal for the first time. So, at page 109, at the bottom in bundle 2, supplemental bundle, bottom of page 109, you can see Mr. Croxford address severance. Mr. Justice Kerr said you've not put forward any brief counselling orally, and then there was complaint about how issue arose, but there was nothing substantive said there.
Reference to a case that was inaudible.
Yes, it was a case in which I was involved. That's what he's talking about. In which my learned friend was involved. That's Egon Zender.
Yeah, I think you said it wasn't referred to. I thought you said it wasn't referred to.
In the skeleton argument. Yeah, I specifically drew the court's attention to it, and Mr. Croxford was responding to that. And then at 115, at E to F.
It says at the top of Mr. Croxford says the first time we saw learned friend's argument was 10 o'clock yesterday. You hadn't served a defence at
No.
no, so they serve particulars of claim and
Reply.
skeleton argument. You say in your skeleton argument it's hopelessly wide.
And in the evidence with our application for summary judgment.
Right. Yes, can we just see that?
Yes. So Ms. Dickens' witness statement is at the beginning of that bundle, starts at page 7.
Yes.
And she's dealing with her view that it was, and you can see it paragraph 9 on page 8, the commission obligation was a disincentive, it didn't protect matters, at paragraph 10 over the page that it was unenforceable. They formed the view that it was unenforceable. Miss Devons, for the first defendant, at paragraph 22, page 14, refers to the correspondence that the commission obligation is void and unenforceable as a restraint of trade. And that's the correspondence which is set out in terms at length, that with reasons that the commission obligation is much too wide. So, for example, my lords, sorry, I have one moment.
Next is 115.
Yes, it's page 220. This is the correspondence she's referring to. Yes, you can see that at the top of page 15. She's referring to page 220, and at 221 at C, all the points there were made about the width of the commission obligation and were relied upon by the parties when applying for summary judgment. So it was fairly put before the court that this was all too wide, and that letter was written before the particulars of claim, my lord. And so they knew that was the attack, and didn't address blue penciling. So I've referred you to page 109. At page 115, at E to F, Mr. Croxford said at the bottom of that submission, it would permit us to remove contemplated if it was not possible to, by way of example, ascribe a greater firmness of meaning to that phrase. And blue pencil that. And then so that was the extent of the submissions before Mr. Croxford was about to sit down. And then at the end of his submissions, at 126, Mr. Justice Kerr at E said, just before you sit down, do you want to say anything further about the commission obligation and severance? You've mentioned the word contemplate, and then Mr. Croxford at the bottom at H said, if you can't read it down, then sever. Sever what? If you need, over the page, if you need to sever contemplate, then so be it. What about the bit that says, or any other person or entity associated with you, including future employee? And Ms. Croxford's submission again there was, if it doesn't need to be severed, summarising what he's saying, but if I'm wrong about meaning, then sever it. And then Mr. Justice Kerr said, yeah, what about the E? What about you shall ensure that? And it's the same response at G. It's enforceable. I say it's enforceable. If I'm wrong about that, it should be severed. So effectively, everything that was suggested to Mr. Croxford, he said, you don't need to sever it, but if I'm wrong, sever it. The one word which wasn't suggested by Mr. Croxford to be severed was discussed, which is now one of the candidate words advanced as a ground of appeal before your lordship. So what Mr. Croxford didn't do was address the test in Egon Zender. He didn't explain how any of that would be met. The burden's on the claimant to persuade the court to sever, and it's not simply open to an advocate to say, well, if you're not with me on construction, you can just sever everything that the court is concerned about.
At this stage, the burden isn't to demonstrate, isn't to establish severance. It's only to establish it would be arguable at trial after it's been established what it means and whether it's reasonable. Then, and that was addressed at 115.
Yes, he's saying you don't sever now, wait till trial. But the problem is it's obviously unreasonable. My learner from Mr. Goulding accepted that that some of the words were, I think his phrase was difficult, contemplated, put him in difficulties, he said. And that is a huge understatement, because it's completely meaningless in terms of how you work out what money should be paid by Mr. Javor, much less my client, when you include a word contemplated. What on earth that means? It can be contemplated without anyone saying anything to anyone. Mr. Javor can be sitting at his desk contemplating something years before the termination of his contract, and that suddenly, years later, employed by my client, it said that my client's in breach of trust by not paying over monies because Mr. Javor contemplated something years before.
Well,
so that's
for
obvious.
my part, I'd take some persuasion within a contract. The word contemplate just means what somebody is mulling over in their own mind. I thought it would be something that would have to to cross the line, there would be some sort of in contemplation between the parties.
Years earlier.
Well, that depends upon whether or not the pleaded meaning is right. Paragraph 28 of the.
Well, Mr. Goulding's submissions to you, my lord, was that there's no need for a time limitation.
What we're dealing with here is striking out the pleading, isn't it? And did the judge ever actually say anywhere in his judgment the construction interpretation in paragraph 28 wrong? Don't you proceed unless you're going to say otherwise? Doesn't the judge have to proceed on the basis of the pleaded interpretation of the clause?
Well, the declaration they're seeking is wrong.
It's the declaration. It's the interpretation of the clause that's been pleaded in paragraph 28 of the particular claim. I thought you took us to that.
Yes, that's the terms in which it seeks a declaration at page 122. The judge was determining whether or not the clause on its own terms was unreasonable. And if on its own terms it is unreasonable, as in my submission it plainly is, then the judge doesn't need to go any further. And the submissions that every element can be penciled is hopeless. So
Just make sure I understood this then. In paragraph 28 is plainly setting out what the claimant says is the correct interpretation of the clause, because that's what it's asking the court to declare what the clause means, and it's valid and enforceable, and then it's what it means after that, isn't it?
Yeah.
So, and the judge is being asked to strike that out by you.
yes,
So where did the judge say that was not the correct interpretation?
I accept in terms he didn't say that, but his explanation of why it is unreasonable necessarily proceeds on the basis that that's wrong. So if your lordship goes to paragraph 100, you would have to account to exile for commission received by him or a person associated with him, including a current employer, even if his discussions with the client were tentative, vague and inconclusive and didn't lead to a booking. So it's a necessary element of that his construction of the clause was that's what the clause means.
That fits perfectly with what's in the clause in paragraph 28, isn't it? What?
No, because there's no at paragraph 102, my lord, he says the commission obligation is not time limited. So that is directly contradicting paragraph 28, where there's a time period.
No, but that's not the same thing. That's the time he's talking about, the time limit after Javor leaves exile.
Well, he might be, but
Well, I think it's fairly obvious in the context, isn't it?
It's obvious, my lord, with great respect, that there is that on the face of the contract there's no retrospective time limit, and that can be contrasted with the non-solicitation clause, which does have one.
But they pleaded the retrospective time limit in 28.
Yes, but that's obviously unarguably wrong, with great respect.
With great respect, I don't agree, and I don't see where the judge has determined it.
I accept that he hasn't determined that point.
And I don't see where he's even referred to it.
He's determining reasonableness, and what the approach that the judge takes is that if it's unreasonable for all the reasons he's set out, then the clause goes, and that's right. If it's unreasonable, then it doesn't matter whether that
Well, I quite accept that he's determined it's unreasonable, but I think what you can't say is you can't make submissions about the basis of interpretation of the clause when that was pleaded by the claimant, and the judge has not said that was wrong. It seems to me the judge has got to proceed upon the basis of the pleaded interpretation unless he determines that pleaded interpretation is wrong, because that is what he's striking. Is it not?
In my submission, that the paragraphs in which he's discussing reasonableness necessarily contain the construction that the judge has reached as well.
That's when you say that. I just can't see that. And I've asked you to show me. I didn't think you've shown me.
Right.
What grounds have we not so far covered?
My lord, yes, it's that it's. Can I just finish? Can I finish severance?
Yes.
If your lordship looks at the clause, which it may be easiest to look at clause tab 10,
Yes.
where the clause is set out more easily. You don't simply need to sever contemplated in my submission, but discussed has to be severed as well. But further words need to be severed too, like, for example, the words that the judge put to Mr. Croxford below. So he put to Mr. Croxford, what about an entity associated with you? Because we have made the submission that associated includes, for example, a shareholding, a minority shareholding. And that was held in Egon Zender, parties proceeded on the basis of Egon Zender, that such an association would be obviously unreasonable. And so you'd need to blue pencil whole swathes of this to make it enforceable.
Well, would you? On a strikeout, if alternative interpretations are possible, and they're both realistic, then you have to take the one which upholds the contract rather than renders it invalid. Certainly on a strikeout, actually, probably on a trial. And if there are said to be fatal defects in the clause, then at this stage, at any rate, one has to look at them one by one. And if it's, suppose that you're right, that all contemplated is hopelessly vague and wide, the judge has to decide the severance issue. Is it obvious that those two words can't be crossed out? If it's not obvious that they can't be crossed out, then that's not a ground for striking out. Then you go to something else. Judges are sort of painted with a broad brush.
Your lordship is entirely correct, and I accept that point, but blue penciling has to be seen in the context of reasonableness generally. And so what you're doing is, and it's, in a sense, the grounds are approached in the wrong way. Blue penciling is ground 5 and reasonableness is ground 6. But once you've reached the conclusion that the clause is unreasonable, then you look to see whether you can blue pencil matters to save it that wouldn't radically alter the meaning of the post-termination restrictions. And so my answer to your lordship is this. It's obvious when you assess reasonableness, as the judge did, that the clause is unreasonable for a whole load of reasons that go way beyond the word contemplated. And let me just make a few points to make that good. First, there is a positive obligation in the 4th sentence to ensure that all bookings are contracted via the company. So this is a case in which there is a post-termination obligation to carry on working for the ex-employer indefinitely into the future to make sure all bookings are contracted by his former employer. That might well put an employee in breach of contract with his obligations to his new employer, for
Or
example.
would it? Because somebody who's subject to that obligation would need to say to their prospective new employer, I'd love to work for you, but I have to tell you that I'm subject to this restriction.
There's no obligation to, there's no informing obligation here. But
No, but there's a contractual obligation.
there's a contractual obligation
It's
to carry on
defined.
working for the former employer.
No,
But
no, it isn't to carry on working. It's to ensure that the contract is in the name of XR.
To ensure that all bookings are contracted via the company. And so if you're positively insuring something, you're carrying out services for someone, and that is, in my submission, accurately described as carrying on working.
So all it means is that when the relevant client comes to you to say, right, I'd like to now go ahead with that booking, you say to them, well, I no longer work for X-Ray. This needs to be done through them.
Yeah, and that is an obvious disincentive for a new employer to employ someone. So it obviously shows that it's a
But that's the question about whether it's in restraint of trade,
yeah.
not whether it's unreasonable.
Well, in my submission, it's obviously unreasonable as well. And an eternal obligation to ensure bookings are made through your ex-employer.
No, Mr. Solomon. It's not an internal obligation
Eternal.
to eternal obligation to ensure that future bookings are made for the old employer. It's an eternal obligation to ensure that specific bookings which were discussed, let's say,
Yeah.
focus on discussed. That is, let's discuss getting Coldplay to do a gig at the O2 Arena on the 12th of June 2025.
Yeah.
The obligation is to ensure that the commission for that should go to the old employer.
Yeah. Well, let's discuss an obligation. Let's discuss a booking for Coldplay over the next 10 years. And then it goes no further. And so for the next 10 years, Mr. Javor has got the obligation to carry on working for X-Ray to ensure that all those bookings are made via it. Mr. Goulding attempted to say that the fourth paragraph, the fourth sentence, is not part of the commission obligation. But you will see the way in which it's put in the particulars of claim is to define in terms sentences 3 and 4 as the commission obligation. That's at page 112, paragraph 9. The third and fourth sentences of clause 13 are together referred to herein as the commission obligation, so that its acceptance, that is part of his obligation. My lords, I've made my submissions on the fact on our case there's no limit for Mr. Javor to have made the bookings himself and no retrospective period. I'm not going to repeat those.
No.
I'm not going to repeat my submissions that there's that on contemplated. Those are the first 3 points. The fourth point on unreasonableness is that the clause bites if Mr. Javor had no role himself in the booking at the new entity. So you've heard from Mr. Goulding the evidence of how teams get bookings and there's a team leader. But you've also seen the non-solicitation clause. So Mr. Javor is not allowed to solicit for a year his clients. And so it's quite possible in the context where he's not soliciting himself for someone else to solicit the client from the claimant. And in that context, Mr. Javor himself would be liable, notwithstanding that he did nothing to solicit or gain that booking, for somebody else's work getting that client. Fifthly, the clause bites if he's merely associated with an entity, irrespective of if his association is a de minimis shareholding. And your lordship said to me when I made this point earlier, but if the court has conflicting interpretations of a clause, then it doesn't need to strike it out. But there was no conflicting interpretation on that provision by Mr. Croxford in the section I've shown you where the judge asked him about it. He just said, if you're not with me on a strong reading of the clause, then blue pencil it. It's not as if there was a conflicting interpretation. But so there's a whole swathe of stuff that needs to be blue penciled. Sixthly, the clause applies to 100% of the commission. Mr. Reed has made submissions about this. It doesn't affect profit whatsoever. It's nothing to do with profit, either Mr. Javor's profit or my client's profit or the claimant's loss. It's 100% of the booking, and that shows the extent to which it's unreasonable. And seventhly, the clause is unlimited temporally, and we say it's unlimited retrospectively and prospectively. And Mr. Goulding has told you it's unlimited retrospectively as well. And that's extraordinarily wide. The last point is that the claimant could have protected its interests by a properly drafted non-dealing clause. What Mr. Goulding said to your lordships is that that wouldn't work. We don't want to interfere with his client relationships. He's welcome to deal with the clients. He's just got an obligation to pay us the money. But the problem that Mr. Goulding abuts is that there is a non-solicitation clause. So it's accepted by the claimant. They can, in fact, interfere with Mr. Javor's client relationships. And there's no principled reason why a well-drafted non-dealing provision with an express retrospective period, an express obligation that the dealing must have been done by Mr. Javor himself in the retrospective period, and an express limitation on a future temporal period, could not have protected the claimant's interests. Why that isn't in place is not explained. And all those reasons, my lords, show how unreasonable the clause is. And it's in that context that you're looking at blue penciling. And what you have to do, I say, is not just blue pencil the candidate words discussed, advanced for the first time today and contemplated, but a whole swathe of other words, and add in words, temporal limitations, prospective and
Of course you can't do that. And speaking for myself, the question, the fourth sentence, it's not a question of severance. It's a question of whether it makes the whole thing unreasonable. And even if, for example, all contemplated can be severed, you can still argue, and you do, that for various reasons the clause, even edited, is unreasonable. I understand that.
Yeah, the fourth sentence, in fact, is simply a mechanism by way for the way in which the third sentence works. So if your lordships look at the clause, it says that all commission, and then about 5 lines from the bottom, shall belong to the company. And so it's already saying we get 100% of it. And the fourth sentence simply clarifies the obligation that you've got to pay us, you've got to ensure that we get 100% of it. So the fourth sentence is exactly part and parcel of the third sentence in any event.
Well, the word shall belong to the company as between X-ray and that may mean something, but when it goes on to say any such commission or the money is received by you, fair enough, that works. But insofar as it's any other person or entity associated with you, well, unless it's his own company, that doesn't do anything, does it?
No.
Because if the money comes to WME,
yeah,
the fact that this contractual provision doesn't bite on that.
No. My client.
And Mr. Javor's undertaking to hold such monies on trust for X-ray does nothing.
Meaningless.
Well, it's not
In that-
meaningless.
it's meaningless
It
in
just
that
doesn't
context.
It just doesn't bite.
In the context where everyone was on the understanding that Mr. Javor was an employee and would go on to be an incumbent employee, which is what everyone seems to assume.
Well, do we know that? He might have set up his own company.
Yeah, he might have done. I accept he might have had his own
I mean,
company.
you see, if he set up his own company, this would have been extremely pertinent.
Yeah. I mean, it's a huge in that context, my lord. It's a massive disincentive against doing exactly that.
That may well be so. Aren't we on a different point now, though?
Well, yes.
Yes.
But I mean, it's not. It's obviously correct that this has a huge. It's hugely problematic and would stop him setting up his own company. But your lordship was saying that none of this makes any difference if he's working for someone else. It just doesn't bite.
It doesn't bite on
My client.
your client. It does bite on Mr. Javor because it may affect his obligations and indeed may affect what he has to say to an employer before he starts to work for
Maybe.
them.
Yes, and if it's right that he's got an obligation to say, you've got to pay 100% of the monies you receive, irrespective of the fact that that doesn't reflect your profit. So you're going to have to pay costs and profit over to my previous employer. That's obviously a disincentive on them employing him, if it's enforceable. As a matter of fact, my clients considered it wasn't enforceable, so it didn't apply.
What you have to say is, my employment would have to be subject to my obligation to, if I deal with these people, to tell them to go to X-ray. In relation to the contracts they discussed with me at X-ray.
Yes.
I'm not sure why that's unreasonable. If you say to your new employer, say, look, I had some discussions with particular artists. I had discussions with artists in relation to the bookings I was proposing to make for them. If they come to me now and say, we'd like to go ahead with those bookings, I'm going to have to say, well, that's got to go through X-ray.
Or next year, or the year after, or at any time in the future, if they come to me.
Well, that's comes to exactly. That's where the scope of the argument is.
That isn't the position put in the particulars of claim, my lord. The particulars of claim advance a retrospective limitation, not a prospective limitation. So even on particulars of claims assertion,
Yes, I understand that.
it's eternal.
I understand that.
So my submission is that a new employer being told that work he might do forevermore because it might have been discussed at some point previously with a client will have to be contracted via the ex-employer. It would be a huge disincentive on employment. And it's my submission, because of the lack of limitations, it's plainly unreasonable and can't be saved by severance. I think I've gone over my allotted time.
You have, but more to the point. I think you've covered 4, 5, and 6, and the particular position of your client. Right, Mr. Goulding.
Lord, I don't know what commitments the court has elsewhere and when you intend to rise. Obviously, I've not got on my feet to say Mr. Solomon has gone over. There's a few matters I do wish to deal with. If your lordship wishes to impose a time constraint on me, I will of course comply with it.
See whether you can get through them in 10 minutes.
Yeah.
I'm not saying that we'll get up and walk out at 4:30, but
I'm grateful. Well, can I deal first with the declaratory relief sought against the second defendant? This was, I think, the first point that Moylan and friend Mr. Solomon took. We start with the judgment the only thing said in the judgment about the claim for declaratory relief against the second defendant is at paragraph 104 in the last sentence, where the judge says the only relief sought is a declaration that the commission provision is valid, a proposition I have rejected. If we succeed on the appeal, that it was not obvious that the commission provision is invalid and therefore the claim should proceed, then we say the claim for a declaration is back in play. The judge has not rejected the claim for a declaration against the second defendant on any other grounds other than that he considered the commission provision to be invalid.
And there's no respondent's notice.
That's my next point, my lord. There is no respondent's notice saying we would like to uphold the judge's decision on the basis that declaratory relief shouldn't have been granted. So this point is not open to my learned friend. He did raise it rather obliquely in his skeleton argument at paragraph 30. This is in Core Bundle tab 3, page 51, where all he says is it's not clear as to why, if all C seeks is declaratory relief in respect of the commission obligation, D2 is a party to the claim at all. D2 is not a party to the contract, entirely unnecessary, not the function of the court to award declaration simply because one party demands it, but solely to determine disputes as to the extent of legal rights. Doesn't even there say the judge's decision should be upheld on the basis that declaratory relief is unavailable. It's simply an observation. It is not clear as to why. That was why we hadn't addressed it previously. But in any event, it's clear on the authorities, particularly the Rolls-Royce case, as my Lord Justice Phillips observed, that in order for the court to grant declaratory relief, X-ray doesn't need to have a present cause of action against the second defendant. There must be a dispute between the claimant and the second defendant as to the existence or extent of a legal right, but there clearly is, because the second defendant has hotly contested, one might say has taken the lead in contesting the enforceability of the commission provision, and so there is a dispute between the parties. If I could just invite the court's attention briefly to another passage in the Rolls-Royce case. It's at tab 14 in the authorities bundle, and at page 247 of the bundle itself, Lord Justice Wall, at paragraph 17, letter F, refers to a submission of Mr. Bowers relying on Dyson against the Attorney General, in which this court had held that a declaration might be granted where it would guide their action in the future. And we say that is certainly pertinent in this case, because if the court grants a declaration that the commission provision is valid as against the second defendant, in our submission it will guide their action as to the future. And we say it is likely in those circumstances that the second defendant will pay the commission due under the commission provision, just as it has recently paid commission, which arises as payable under the commission provision. The claim for declaratory relief, as one has seen, is clearly set out in paragraph 28 of the particulars of claim, and there is every reason why, if the court is with us, that the enforceability of the provision is arguable, that relief stands.
When you say valid as against the second defendant, What's the legal basis for asserting that it's valid as against the second defendant as pleaded?
Lord, we say it's valid and enforceable as against the first defendant, and we seek declaratory relief that it is valid and enforceable, and we seek the declaratory relief against the second defendant.
Sorry, I thought your submission was that the declaration you were seeking that it was valid and enforceable as against the second defendant.
No, my lord, in which case I didn't express myself clearly enough. We seek the declaratory relief against the second defendant, that the commission provision is valid and enforceable. There is a dispute.
Valid and enforceable as against the first defendant?
Yes.
So what does including the second defendant within these proceedings add to the declaration you're seeking as against the first defendant?
Well, of course, the second defendant is a party to the proceedings for inducing the breach of the non-solicit provision. That's how they, for that claim,
Yes.
come to be parties. In relation to this claim, we say that the claim to declaratory relief is within the discretion of the court, within the jurisdiction of the court, because there is a dispute between the claimant and the second defendant as to the enforceability of that provision. The second defendant maintained in correspondence and has maintained in these proceedings that the provision is not enforceable. There is therefore a dispute between us and the second defendant as to the enforceability of that provision. And that therefore means the precondition identified in Rolls-Royce for the court's jurisdiction to grant declaratory relief is established. And because it is the second defendant that we say is pulling the strings here, both in terms of making the running in this action and also would be the party that practically would pay the commission, then there is good reason for the court to grant that declaratory relief as against the second defendant. In any event, I go back to my original point that the judge only dismissed the claim on the basis that provision was invalid, and there's no respondent's notice seeking to uphold that finding on any other ground, such as declaratory relief would be inappropriate or wrongful exercise of discretion.
Another decision after Rolls-Royce's Marlbush, much the same effect.
Yes, well, I think that's right. And we put into the authorities bundle the latest edition of Zamir and Wolf on declaratory judgments. And it does discuss some of the cases post Rolls-Royce.
Well, there was another one this morning.
Well, I didn't think that one up, I confess. But for my Lord's note, it's tab 27 of the bundle, page 533 in particular. They pick up the post-Gourier jurisprudence, and at 535 discuss Rolls-Royce. And then at the bottom of 535 discuss a case called Milebush against Thameside. Right, maybe that was the one my Lord mentioned. Lord Justice Mummery saying authorities show how declaratory relief may be granted in private law proceedings about the disputed construction of a document affecting the claimant, even though the claimant was not a party to it. And my Lord, that's almost my 10 minutes on the declaratory relief point. Can I just look at my notes, and I hope my Lords will forgive me if I go very quickly.
Or just take a moment to look through before you make your selection.
Lord, on construction was addressed below. Our skeleton makes clear that the construction is fundamental to the other grounds of appeal, and we simply don't know what the judge has decided on construction, and that is a fundamental error that permeates his reasoning. In terms of what is the legitimate interest and what the common law provides, we have included in the authorities bundle and referred to in our skeleton some extracts from Bousted, as well as Snell's Equity. Just briefly, the Bousted extract is at tab 25 of the bundle, and at page 517 we see Article 48, which states an agent may not, in breach of duty, acquire a benefit from a third party without the principal's consent. The agent must account to the principal for any benefit so obtained. And one sees at 519, 5 lines up from the bottom of the page, the agent may be liable even though by the time the opportunity is exploited, the agent has ceased to act for the principal. Indeed, the person concerned may often have resigned as agent precisely in order to pursue the profit. And to a similar effect, behind tab 26, at page 527, from Snell's Equity, the top 3 lines, a fiduciary is required to account for any benefit or gain obtained or received by reason of or by use of his fiduciary position or of opportunity or knowledge resulting from it. So we say by analogy, that is what this commission provision seeks to achieve as a matter of contract. And the common law position supports our third ground. The common law rules are not treated as subject to the doctrine of restraint of trade. And we say, even if the commission provision, contrary to our submissions, is a restraint, it should not be subject to the doctrine of restraint of trade. And if that is correct and it's not subject to the doctrine, then the 100% element doesn't come into play because it's not subject to any reasonableness requirement. It might come into play if it is deemed subject to the doctrine of restraint of trade, but we say, well, that is the contractual arrangement into which Mr. Javor freely entered, and is one element in the reasonableness assessment that should be conducted at trial. On Stenhouse, not only were there references to the trial judge indicating that there was a trial in that case, but could I just draw the court's attention to Lord Wilberforce's speech at 402 D to E, where in dealing with the particular argument on duration in that case, this is page 14 of the authorities bundle, he said just below D, it is for the judge, after informing himself as fully as he can of the facts and circumstances relating to the employer's business, the nature of the employer's interest to be protected, and the likely effect on solicitation, to decide whether the contractual period is reasonable. Whilst those words are specifically directed to duration, we submit they're of general application in a case of this nature. In these novel circumstances, dealing with a provision that has not been subject to consideration by the courts before, it should be for the trial judge to inform himself as fully as he can of the facts and circumstances before deciding whether a provision is a restraint of trade, or if it is, whether it's reasonable. And we make a similar point about quantum paragraph 60, little 1, to which my learned friend Mr. Reed refers. As one reads on in the judgment of Lady Justice Carr, it's apparent that she doesn't accept that the trading society test laid down in Peninsula is the definitive test to be applied in all cases, but each case is to be looked at on its own facts to decide where to draw the boundaries as to whether the restraint of trade doctrine applies, see in particular para 60 subparagraph 3, and paragraph 72, that the Trading Society test is not an exclusive test. And where one is dealing, as we submit with, one is here dealing with novel, difficult questions in this uncharted territory as to whether this sort of provision is unenforceable as an unreasonable restraint of trade, that should not be decided on a summary basis. Lord, as for legitimate business interests, we submit they are set out and pleaded in paragraph 27.2 of the particulars of claim. Mr. Solomon seemed to be adopting an exercise where form triumphs over substance. Because the words legitimate business interests were not used, he submits that the interest identified in 27.2 cannot be a legitimate business interest. We say that's clearly wrong in principle and is contrary to what Lord Justice Evans said in Dorney Day, where it was held that a financial investment in a business enterprise was a legitimate business interest. Lord, as to severance, my lords have seen that severance was raised in submissions below. The claimant had proposed before the hearing, in advance of the hearing, that there should be sequential exchange of skeleton arguments, with the defendants first serving their skeleton, so the claimant could see what were the particular points relied on by the defendants. The defendants didn't agree and no order was made, so there was simultaneous exchange of skeleton arguments. So the claimant didn't know precisely what were the points to be taken on reasonableness until the skeletons were exchanged. And therefore, that explains in part why Mr. Croxford dealt with severance issues orally at the hearing rather than in skeleton argument. Lord, as to particular phrases, entity associated with, we say clearly refers to an entity that Mr. Javor might have set up through which to trade personally, and certainly doesn't render the covenant unreasonable. The fourth sentence, to ensure all bookings, has limited effect in its context. It simply means that where Mr. Javor has worked on concert bookings before the termination of his employment with X-Ray, if he continues to work on those bookings for artists, which he's perfectly entitled to do, he should ensure that they're contracted through X-Ray. That is a limited exercise that would ensure that the commission is payable to X-Ray. If he doesn't do that, then he should account for the commission in that limited fashion. I think the court has my submissions as to why we say a non-dealing provision would be more restrictive of Mr. Javor than the commission provision. And we say the fact that William Morris has still engaged Mr. Javor knowing of this provision is itself compelling evidence that it does not operate in practice as a restraint of trade. Lords, I'm sorry for the gallop to the finishing line. Unless I can assist any further, those are our submissions.
Thank you. You've all been very helpful. We seek to apportion blame as to why it's now 20 to 5. It may be that we ask so many questions, but these things happen. We're very grateful to all for your submissions. We will, of course, reserve judgment. We'll send out a draft in the usual way. All the experienced counsel in this case know what I'm about to say, but I still have to say it. Two things about the hand down, about the draft and the subsequent hand down. The draft is not sent out for the case to be re-argued, only for obvious factual errors and typos and so on to be pointed out. The contents of the judgment are confidential to the parties and their legal advisors until the formal hand down, which will be by publication on the National Archive and so forth. Any ancillary matters, including costs, should be dealt with in writing, and if there's any disagreement about the form of order, that can be flagged up in writing. It's pretty well inconceivable that an oral hearing would be required on any matter connected with the handing down of judgment. Thank you all very much for your assistance.
All right,